Hello, today we will be presenting on human rights in the workplace. Human rights, also referred to as fundamental rights, are rights inherent to all human beings and related to human dignity. The legal sources of human rights at a universal level come from the Universal Declaration of Human Rights from the United Nations in 1948, the International Covenant on Civil and Political Rights in 1966, and the International Covenant on Economic, Social, and Cultural Rights in 1966, and at a European level from the European Convention of Human Rights in 1950 and the Charter of Human Rights of the European Union in 2012. More specifically, we are going to be focusing on human rights in the workplace. Rights directly associated with the work environment are freedom of association, the right to strike, the right to work, and the right to collective bargaining. Other individual human rights that are not employment specific but that should still be considered in the workplace are the right to equal treatment and non-discrimination, the right to privacy, and the right to freedom of expression. Now, let's look at the principle of equality. The principle of equality stipulates that individuals who are in similar situations should receive similar treatment and not be treated less favorably unless objective reasons exist. The basic concepts of equality are equality of opportunity and prohibition of discrimination. Grounds of discrimination can be found in three different EU directives. EU Directive 2006/54 ensures the implementation of the principle of equal opportunities and equal treatment of men and women in matters of employment and occupation. EU Directive 2078 lays a general framework for combating discrimination on the grounds of religion or belief, disability, age, or sexual orientation as regards to employment and occupation, and EU Directive 2043 combats discrimination on the grounds of racial or ethnic origin. Now, let's take a look at privacy. Privacy in the workplace is defined as the right of the workers to keep their dignity and have their private lives remain personal. In Spain, it is regulated by three main laws: the Reglamento General de Protección de Datos, the Ley de Protección de Datos, and the Estatuto de Trabajadores, together with the constitutional rights. The company's rights to control and monitor the good performance of their employees may, however, at times clash with the workers' rights to preserve their privacy. Three examples of these clashes can be seen with video recording, job interviews, and medical tests. Employers can only record their workers to make sure that they perform appropriately and only if certain requirements are met, such as if the recording of the workplace and other vital tasks is absolutely necessary for job evaluation. In job interviews, some questions are considered violations of a candidate's privacy, such as their race, nationality, age, sexual orientation, religious views, and family situation. And lastly, medical tests are absolutely only allowed in cases where they result as vital for the correct performance of the assigned tasks in the workplace. Lastly, let's talk about freedom of expression. According to the Ley de Contrato de Trabajo, the employee will be free to freely express their opinions about political, religious, or sexual orientation issues as long as it does not interfere with the proper performance of their duties in the company. Furthermore, employees are in contact with private information of the company, so they are obliged to comply with the duty of secret and sign a confidentiality contract. Now that we have looked at human rights in the workplace, there comes an important question of, are we always entitled to these rights? The answer is not always. That is why we have the proportionality test. The proportionality test is a four-stage test used to determine whether or not it is appropriate to restrict the rights of a worker. First, the company must be able to identify a legitimate objective. Second, it must be adequate to achieve the goal. Third, the restriction must be really necessary to protect this legitimate goal. And fourth, the protection of this legitimate goal must be more valuable than the restriction of the human rights of the workers. Now that we have looked at human rights and when it is appropriate to restrict them, let's look at who protects these rights. These rights are protected by the European Courts of Human Rights, the Charter of Fundamental Rights of the European Union, and there is also domestic protection, such as the Spanish Constitution. We hope you have enjoyed learning about human rights in the workplace, and we thank you for watching our video.